Item number 11, House Bill 26 by Chairman Todd.
Motion. Second.
You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. Glad to finally get to see you guys in here. Y'all been doing a lot of work and staying late, I know. House Bill 26 is what I'm calling a self-defense cleanup bill. One of our most seasoned attorneys in this building brought this to me a couple of years ago as we were discussing some other legislation and said that over the years he has found, not only from a Supreme Court decision, but also from talking to other folks and doing research, that we had an error in the law that is really a trap for folks. And what it says currently is that you can use the defense of self-defense as long as you're not involved in unlawful activity. And that is the trap. What is unlawful activity? And the Supreme Court told us years ago that that is, in fact, something that needs to be changed. And so what this does, it defines what that activity is. And so that is the essence of this bill. It just puts in code what the definition is, what things are excluded from self-defense.
Thank you for that. Any questions for our sponsor, Representative Beck?
Thank you. And to the sponsor, I'm a little confused on this, and I read it. It seems like you can now claim self-defense if you're committing a B misdemeanor or lower. And why? I'm a little confused on this. Can you straighten me out, Mr. Sponsor?
Yes, sir. Thank you, sir. So this would change unlawful activity to conduct that would constitute a felony or Class A misdemeanor. That's what the bill does. So instead of saying unlawful activity, it defines it as if you're committing a felony or a Class A misdemeanor, you could not use self-defense as a defense.
Representative Beck?
But if you are committing a B misdemeanor or lower, you can use self-defense as a defense. Is that correct?
I believe that would be the assumption.
Okay, and what would be, since I don't do criminal law, what would be some of the offenses that are Class B and C offenses?
I'm going to look and see if I have that list. I have had it in the past, so I'm going to check
sir.
to see if it's in this file, because we went through that with legal to make sure that we're not including things that shouldn't be included, and their recommendation was this definition, and I don't know that I have that.
If you don't have the list, we can go out of
I don't have
session
that list.
and ask from legal services.
Please,
I almost said out of
Mr.
service.
Chair.
I almost did it. We'll go, without objection, we'll go out of session and hear from legal.
Michelle Fogarty, Legal Services. There's a long list of offenses that are a Class B and a Class C misdemeanor. Would you like for me to read them all to you?
Let's just read B.
Okay. 3913-101A3, assault, offensive or provocative physical contact, communicating a threat concerning a school employee, indecent exposure with no statutory aggravating factors, public indecency, first or second offense, punishable by a $500 fine only, prostitution under subdivision B1, disclosure of surveillance image captured via unmanned aircraft, falsely reporting credit card or debit card lost, stolen, or mislaid, issuing false financial statement, deceptive business practices, fraudulent transfer of a motor vehicle, failure to disclose location to the owner, interfering with customary agricultural practice on animals, removing electronic or radio transmitting collar from dog to prevent owner from locating dog, leaving fire near woodland unattended, aggravated criminal trespass other than habitation, hospital, or school, mailbox vandalism, defacement of state property with graffiti, throwing or shooting object at train, bus, motorcycle, or watercraft, criminal littering, hauling litter in unsecured manner, maliciously inducing contaminant or virus into a computer system, damaging animal facility or freeing animals therein with damage of less than $500, disseminating smoking paraphernalia to a minor after 3 prior violations, misuse of official information by a public servant, resisting stop, frisk, halt, arrest, or search with no weapon, or obstructing service of process, use of radar jamming device to interrupt law enforcement signals, abandonment of airtight containers, seller of radar detection or jamming devices, disrupting or obstructing meeting or a procession, obstructing a highway or other passageway, disorderly conduct at funerals, gambling promotion, possession of a gambling device or record, making a lottery, chain letter, or pyramid club, sale of a lottery ticket to a minor first offense, failure to file charitable gaming financial accounting, unlawful sale of alcoholic beverages without a license, possession of a still, possession of software for purpose of interfering with operations of a ticket seller, unlawful possession of a weapon with intent to go armed, second or subsequent offense, carrying a firearm on school property absent an intent to go armed, confiscation and disposition of confiscated weapons in an unlawful manner, violation of a handgun permit law not otherwise provided, fine not to exceed $500, possession of a weapon on posted property, displaying in a threatening manner an imitation firearm, conveying dangerous materials to a metals recycling facility without consent, and failure to comply with or enforce the Children's Act for Clean Indoor Air. Those would be the Class B misdemeanors.
Yes, sir.
Very good, thank you. Legal, I'll wait till we go back into session.
Okay, any other questions for legal while we have her? Seeing none, we'll go back into session. All right, Representative Beck?
Thank you, and to the sponsor, there are certain ones on there I can see why you would not want to give up your ability to claim self-defense. But when you have a weapon on a property posted, no trespassing, or you're doing criminal trespassing, and there were a few others, why would we give them the ability, if you're criminally trespassing, or you've got a weapon on property that's posted no trespassing, why would we want to give them the ability to shoot somebody and then claim, oh, it's self-defense?
Thank you, Mr. Chairman. I don't believe we're giving someone the authority to shoot someone and then claim self-defense if it was not truly self-defense. But if you do find yourself trespassing and someone threatens you with bodily harm or death with another weapon, I think you still should be able to defend yourself. That's not, I wouldn't want to take someone's ability to defend themselves when they're only trespassing or only littering or only illegally parked. There are a number of things that this covers that in the Class B misdemeanors is why we left that out.
I agree with you with the parking, but I didn't hear that in the list. But the credit card fraud and buying somebody a lottery ticket and other things, I agree with you on. But I think you're throwing out some things. When I grew up on a farm and we had hunters come onto our property that was posted no trespassing, when you confront those hunters, it's just you, the hunter with the weapon, and this, you know, he could say, oh, he was coming at me and I was in fear for my life, so I shot him dead, and now I'm claiming self-defense, even though I was violating the B misdemeanor. So I can't support that. I think if it was more narrow on the list, I could support it, but I can't support it as it comes today. So, but thank you.
Thank you, Mr. Chairman. I have personally experienced the exact situation you're talking about. When I was much younger, I had an individual that was trespassing that had 2 weapons on him. And fortunately, he didn't draw those or point them at me, but had he fired a shot, I would have certainly wanted to be able to defend myself. And I wasn't the trespasser in that situation. But by the same token, had I shot at him for no reason, which I could not lawfully shoot at him, just because he's trespassing. That's not something that is a threat to my life or bodily harm. So I would not want him to give up his self-defense ability there to defend himself if I was doing something illegal. That's all this is doing, is protecting folks, the law-abiding citizens, again, if they're creating something or have an offense that's in this category of a Class B, that they still should be able to defend themselves.
Representative Beck.
I don't know if we got a misstatement there or not, but when you met that person, you weren't that was carrying guns. you were not trespassing. You were on your property. You met him or her while they were trespassing on your posted property. Self-defense is available to you because you aren't committing any crime under this bill. But the person who's got the guns is committing a crime under a B misdemeanor, and we're going to give them out in the middle of nowhere the ability to shoot you and claim self-defense, basically, under this bill. So that's the reason I can't support it. But I thank you.
And all I'm saying is I would not have wanted to take that person's right, even though he was trespassing. That crime does not supersede, it doesn't rise to the level, and I think that's why it's in the Class B category. It doesn't rise to the level of a person giving up their right to defend themselves. If I had done something as the landowner, had done something offensive to him, like shoot at him for something that he should not have been shot at for, or to create that situation, I wouldn't want to take his defense away, is my opinion there.
What about criminal trespass, as she read? Why would we want to give somebody who is criminally trespassing the ability to kill someone and say, oh, I was scared they were coming at me. They came out of the shadows. They scared me. I was in fear for my life. And then they've got an absolute right to take them down.
And I don't know the difference, quite frankly, between criminal trespassing and trespassing. So that may be something that you could educate me on. I'm not sure the difference there.
Can we ask legal to define criminal trespassing, please?
Without objection, we'll go out of session. Hear from legal.
Michelle Fogarty, Legal Services. Criminal trespass. A person commits criminal trespass if the person enters or remains on property or any portion of property without the consent of the owner. Consent may be inferred in the case of property that is used for commercial activity available to the general public, or in the case of other property when the owner has communicated the owner's intent that the property be open to the general public.
Very good, thank you.
Any other questions for legal? Seeing none, we'll go back in session. Representative Beck, do you have any other comments?
No, but thank you, Mr. Chairman.
Thank you. Next on our list is Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing the bill. I think I was involved in at least one of the conversations that you're referencing where the kind of genesis of this bill came from. And so I agree. I think it's something that needs to be defined and tightened. And, you know, one of the examples that was given under that list was, you know, leaving a fire near woodland unattended. So if I'm, you know, in that example, and this is not, I mean, I know it sounds like a silly road to go down, but this was exactly the type of thing that we were talking about in that conversation, which prompted this bill, is that if I'm, you know, building a campfire and someone begins to attack me or comes near me to threaten me and I have to defend myself and I leave that, then technically at that point I am not able to apprise myself of that self-defense defense. So I know it sounds like we're cherry picking there, but that's exactly the point, is that you don't want somebody to lose their right to defend themselves because they are doing something, you know, minor. So I appreciate the spirit of the bill, and like I said, was involved in those initial conversations. So I appreciate you bringing this today.
Thank you. And one of the examples that our expert in legal gave me when he first brought this was, if a gentleman was driving down the road and his pregnant wife called him and he didn't want to be driving, if he didn't have a hands-free device, he wants to pull off the side of the road to take that phone call. When he's illegally parked and someone walks up to him to, let's say, hijack him and carjack him, if he shot them or shot at them or pulled a pistol on them, he legally was in violation of this law right now as it stands because he was illegally parked. He was involved in unlawful activity. That's all we're trying to correct here. So thank you for that.
Leader Lamberth.
Thank you to my friend from Davidson County. Thankfully, in the law, you can't shoot somebody for trespassing. And so if in this state, trespassing is a minor crime. It's something that, you know, usually carries a C or a B misdemeanor. There is an A misdemeanor version that this bill would not affect. But if you happen to wander out on somebody else's property and you miss the no trespassing sign, they can't come at you and threaten serious bodily injury or death to you. And if they do, you can defend yourself. That's exactly what this bill says. It just says if you're committing a very minor crime like trespassing and someone tries to kill you, you can defend yourself. And then everything else that was mentioned in the back and forth a while ago, I just, with all due respect, I mean, is something for a jury to determine. This puts it in the jury's hands. I mean, it doesn't say it's automatic. It just says that you can at least make a self-defense argument. And then if the jury believes factually that that's what occurred, then, you know, you're not guilty of that. But right now, the way the law stands, if you're committed even the tiniest of misdemeanors, you can't even assert self-defense, exactly as the chairman gave us an example a while ago, and was the list given by legal. So, I mean, it seems to me to be a significant step forward in the law so that we don't allow a minor misdemeanor to preclude someone from literally saving their own life. So I appreciate you bringing the bill, certainly support it.
Thank you, Leader Lambert, and thank you to my friend from Davidson County. That's what the subcommittee's for, is to vet these things out and make sure it's a good bill before it goes on, and I appreciate that. I know that you always look for those situations that someone else may have missed, and that's what we want. That's what this process is for, so I do appreciate that.
Any other questions for the sponsor? Seeing none, question has been called. Any objection? Seeing none, we're now voting on sending House Bill 26 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Your bill moves on to full criminal. If you wish to be recorded as a no, please see the clerk.